Masechet Sanhedrin Daf Kaf Chet. We learned the Mishnah yesterday that close relatives cannot be witnesses against each other, nor can one be a judge if the litigant is anyone on this list. The list was mostly uncles, paternal uncles, maternal uncles, including through marriage, and also a brother-in-law, son-in-law. And then significantly it says not only these people, but also their children and their sons-in-law are included. So therefore, focusing on the uncles, so their children would be someone's cousin, even someone's cousin through marriage, one cannot testify in any case that involves that other person. Also, the two witnesses cannot be related to each other in any of these relationships. The Gemara yesterday started asking, what's the source? And it quoted this pasuk, Lo yumetu avot al banim, ubanim lo yumetu al avot. Now, the simple reading is that this means that someone is only punished for their own sin. But we know that from the last three words, ish bechet o yumatu. And therefore we learn from the rest of the pasuk that we do not put to death in court a father based on testimony of a son, nor a son based on testimony of the father. Now, there's some redundancy here. Why do you need both of those clauses? And in addition, avot is plural and banim is plural twice. So we're going to use those plurals and these doubles to learn all the other cases on the list. So the Gemara starts, Ashkechan avot lebanim, ubanim leavot. So we have a source for fathers to sons and sons to fathers. When the Gemara says this, it means not only fathers and sons, but also uncles and nephews. And you can know that just from the plural of the word avot. It says fathers, so that's referring to two brothers who are both fathers, and that means they cannot testify against not only a father and son, but also a nephew against his father's brother. So that would also be prohibited. So we know that. And v'kol sheken avot adadeh. Now, if a father and a nephew cannot testify against each other, then all the more so two fathers, meaning two brothers, cannot testify against each other because brothers are closer even than a nephew. Good, we know all that. But here's the question, banim lebanim minelan. What about a son of a father and a son of another father? The fathers are brothers. In other words, first cousins. How do you know that a first cousin cannot testify against his first cousin? That's the question. And the answer is, Im kem lichtov kera, lo yimetu avot al ben, my banim, dafilu banim lahadadeh. If it was only nephews that weren't allowed, but cousins were allowed, then the pasuk could simply say that fathers cannot be punished because of a son. Then I would know that a son of one of the brothers cannot testify about his father or his uncle, and vice versa, uncle to nephew and nephew to uncle. And that I would only have to have ben as a singular to learn all that. Why is ben plural? This means that even the sons of two brothers, meaning first cousins, they also cannot testify one against another. Against or for, we'll see that in a second. Ashkechan banim lahadadeh, banim la'alma minilan. So now I know that we would not punish one cousin because of the testimony of another cousin. But what if the two cousins want to be witnesses together? They together saw a third party not related to them commit a crime. What's my source that two cousins cannot be witnesses together? Amar Rami bar Chama, sevarahu kedatanya en ha'edim na'asim zomin ad shehizomu shenehen. V'yisaka da'atech banim la'alma kesherin, nimsa et zomem neherag ba'edut achiv. Rabbi bar Chama says, I can figure it out through logic, based on the following law that we know from a Braita. The Braita says that the witnesses do not become edim zomemin unless both of them are found to be edim zomemin. In other words, you have two witnesses, they said, we saw a murder. And then if only one of them is found to be an ed zomem because he was in another place, second set of witnesses come and say, one of these witnesses was with us in a baseball game in Chicago. Then they are not killed as edim zomemin because both of them have to be found to be that they were elsewhere. They don't have to be in the same place, but the point is that both of them, there is testimony that they could not have seen that original murder. That's the law of the Braita. Now here's Rami bar Chama's reason. If you think that two people, two relatives, could be cousins, let's just say brothers, so it would be the same law. If you think that brothers can be witnesses together against someone else, against a third party in let's say a murder case? Well, and if so, then if they both are found to be edim zomemim, they would be killed. And in part, it's because of the testimony of the other brother. In other words, as we just saw, if you have two brothers who are testifying about something, and only if both of them are found to be lying and they were elsewhere, then they both would be killed. So that means, let's say, pick any one of the brothers. This brother is being killed because of the testimony, the false testimony that the other brother gave. And we already know that you cannot kill one brother because of the testimony of another brother, or any relative. Any relative cannot be killed because of the testimony of the other brother. But if you accept that two brothers, can testify against a third party, and they are found to be edim zomemim, then you are killing one brother because of, dependent on the fact that his brother also testified and was found to be an ed zomem. So that's just proof that relatives cannot testify together. אמר לרבה, ולטעמיך, הדתנן שלושה אחים ואחד מצטרף עמהן, הרי אלו שלוש עדויות והן עדות אחת להזמה. Rava says to Rami Bar Chama, according to you, how will you explain the following Mishnah in Masechet Baba Batra that says, let's say there's three brothers and one other person who's not related, and someone is trying to prove a hazakah, that he was on the land and lived there for 3 years. And now each one of the brothers testifies about 1 year. So brother number one testifies, I saw this guy there for 1 year, and he joins together with the person who's not related. We'll call him Bob. And then for the second year, a second brother testifies, I saw him, this guy, he was squatting on the land the second year, and he testifies with Bob. And then for the third year, a third brother comes and testifies also with Bob. So the Mishnah rules that is a valid chazakah. You have to bring proof that you were using this field for 3 years straight, but it doesn't have to be based on just two sets of witnesses. You could have separate witnesses for each one, and the chidush is, even though there are brothers involved. Now, two brothers wouldn't be able to come together, but since each brother is testifying about a different year, so it's 3 separate testimonies, but we can combine them all to make a chazakah. Very good. And furthermore, that this is considered one testimony when it comes to hazama. In order to make these edim zomemim, it's not sufficient just to get Bob and one brother to say to get be edim zomemim. They won't have to pay. When will they pay? Only if all 4 people are found to be edim zomemim, because only all 4 people together are effective in giving the rights to this person, that he can. It's that the land is his, and so therefore, if all 4 people are found to be edim zomemim, meaning 2 other witnesses come and say they were all in different places during those 3 years and could not have seen this, then they have to pay. Bob will pay half of the amount of the loss that would have happened to the defendant, and the other 3 brothers split the other half of the loss. That's what the Mishnah says. Now, here's the question. Nimsa ed zomem mishalem mamon be'edut achiv. What you do see here, and this Mishnah is accepted by everybody, is that an ed zomem is paying money because of the testimony of his brother. In other words, Rami Bar Chama, according to you, if you think that there's a proof for that 2 brothers cannot testify against someone else, because if they were to be found edim zomemim, then one would be paying on account of the testimony of his brother, and you cannot punish someone based on the testimony of his brother. Well, then how will you explain this Mishnah where it's totally accepted that they are edim zomemim, even though they are brothers, and it's on account of the testimony of one of the other brothers that each of these brothers has to pay? So we see based on testimony of brothers, and is definitely accepted, because they're talking about 3 different years, so we accept their testimony, and yet they can be found to be edim zomemim, even though their being an ed zomem and having to pay is dependent on their brother's testimony. So this undoes your logic. Rather, what you have to say to explain this baraita is that the hazama, the making someone an ed zomem, comes from elsewhere. It comes from the second set of witnesses that come and say, you were with us in a baseball game in Chicago, you could not have seen this person on the land. And therefore, therefore, we could say the same thing in a regular case where it's just two people, two brothers or two cousins that are coming, and they testify about someone, and let's say they would be edim zomimim, so they would be able to punish one against the other because of the testimony of the other people that are coming. That's what makes them edim zomimim. They're being edim ed zomem. We don't consider that dependent on the testimony of the other. They're not testifying about each other. They are both testifying about something else, not related to them, and they would be edim zomim because of the testimony of someone else. So therefore, your proof is not a proof. In fact, the law is that that cousins and brothers cannot be witnesses, but it's not because they are found to be edim zomimim and one is killed because of the testimony of the other. They're not killed because of the testimony of the other. That could perfectly well happen, as it does in this Mishnah. So rather, we need a different source. Ela im ken nichtov kera uben al avot. Rather, it's because of the second half of the pasuk. Fine, we got lo yumetu avot al banim, but the second half, when we know we has to say banim, that's where we learn that cousins cannot testify against each other. How do we know that two cousins cannot testify together against someone else? Or that we can learn from the second instance of ubanim, that's in plural. It could have written uben al avot and has plural. Iname hem al avot, or it could have written those the banim. Lo yimutu avot al banim vehem. Well, we just referred to. Just use a pronoun. Why do you have to repeat the word ubanim? So either it could have written that either way, but the fact that it says banim, a repetition in plural, that shows that cousins cannot testify together about someone else. Umay ubanim, afilu banim le'alma. So why does it say ubanim? That's to teach that cousins cannot testify against anybody else. Ashkechan kirobe ha'av. So far, we proved that relatives on the paternal side cannot testify about each other or together, because we're talking about avot, so everything was about paternal side. But what about relatives on the mother's side, like the mother's brother, right, an uncle from the mother's side, and cousins on that side also? Amar kira avot avot tedezimne imeno inyan likrobe ha'em teneo inyan likrobe imeno inyan likrobe ha'ab. That's from the repetition of the word avot. Avot here and avot again there. Why do you have to say avot twice? So we have an exegetical rule. If it's not to teach something about this context, it must be teaching about a different context. So we already know about the paternal side from the first instance of avot. The second instance of avot is teaching us that not only avot, not only paternal side, but also the maternal relatives. Ashkechan lechova lischut minelan. Now we know that someone cannot be put to death. That's the context of this pasuk. You can't put to death someone based on the testimony of a relative. So now I know that will be to a detriment if they're testifying against someone that this person committed a crime. But what if they're testifying to the benefit of someone, right? To get someone off the hook. So how would we know it? Because this context is only to someone's detriment. Amar kera yumetu teretzimne imeno inyan lechoba teneo inyan lizchut. Because of the word yumetu, that's also repeated twice in this pasuk. Yumetu here and yumetu there, and so this means to the detriment. But it's repeated twice, so it's not talking about detriment again. So if it's not talking about this context of detriment, it must be talking about the context of testifying on someone's behalf for their benefit. Ashkechan b'dinei nefashot b'dinei manot minalan. I know capital cases it says, right, don't kill someone based on the testimony of another. What if it's only a monetary case? Amar kera mishpat echad yeh lachem mishpat hashaveh lachem. Pasuk says you should have one law. One law means one law for all cases, monetary cases and capital cases. It's true there are some differences between them, but essentially they are the same when it comes to this law that relatives cannot testify for or against each other, not only regarding capital cases, but also monetary cases. So far, we learned that first cousins cannot testify against each other, but now we're going to try to explore what if you go further than that, like a first cousin once removed, a second cousin, and so on. How far will it go? So here's a statement of Rav that we're going to analyze in depth. Amar Rav, Achi Abba lo ya'id li, hu ubno v'chatano. Af ani lo a'id lo, ani ubni v'chatani. So he says, my father's brother. So Rav, imagine, is is the guy in the white. And he's saying, my father's brother, so that's his uncle, cannot testify about me. And not only him, but also his son and his son-in-law. Okay, so that's a simple understanding, right? This is first cousin, and right, first cousin, regular or through marriage. So that everybody agrees with. That's a simple case. But now he says, Af ani, so too I, lo a'id lo, I cannot testify about my uncle, and not only me, but also my son and my son-in-law. Now you can see that the analogy is not exactly the same, because when it comes to first cousin, so this is like one vertical, horizontal, and one vertical. And the Rav seems to be saying that, well, that's the same if you have, two verticals altogether and one horizontal, so you could put it in a different configuration. You have two verticals here, right? The third to second generation, second to first generation, and one horizontal. So in that sense, yeah, I guess they're the same. But it's not necessarily true that you can map one onto the other, right? Who said that just because first cousins cannot testify against each other, that also means that a great uncle and a great nephew cannot testify each other? That is a bit of a different relationship. So that's what we ask. Havale shelishi barishon. Okay, we use like first cousin, second cousin, but the Gemara doesn't use that language. It uses the generation. Shelishi means the third generation against the first generation. So we only know that second generation and second generation cannot testify against each other. And now, Rav, you're extending that to a case of third generation and first generation. Who says it goes down two generations, that a great nephew and a great uncle would be prohibited against each other? So that's the question. So the answer is Mai chatano de katani bematnitin chatan beno. When the Mishnah said that all of these people cannot testify about each other, and that includes also the sons and sons-in-law, don't read that as meaning the son and son-in-law of the uncle, which is the simple reading, but rather it's the son and the son-in-law of that son. In other words, the grandson-in-law of the uncle. You can see it on this chart. If we are talking about this person here, and so the Mishnah says this person's uncle, they cannot testify about each other. And then this person and all the people on this list, that includes the son, so that would be this here, the first cousin. And when it says son-in-law, it's not the son-in-law of the uncle, but rather the son-in-law of that son, right? So his son and the son's son-in-law. That's what the Mishnah said is prohibited. Interestingly, this goes even beyond what Rav said, as the Gemara will point out in just a minute, because Rav was only said that 1 and 3 are prohibited from testifying about each other. But according to this interpretation of the Mishnah, even a second generation and a third generation on the other side, what we would call first cousin once removed, would also be prohibited from each other. Okay, so keep that in mind. But anyway, this is the answer to the question. Where did Rav get this from? It says so in the Mishnah, if you read the Mishnah in this way. Now we ask about that reading. Vilitne ben beno. If so, why would you write it in such a strange way, right? The uncle's son and that son's son-in-law. Just say the uncle's son and the uncle's grandson. That would be much clearer. And the answer to that is Milta agav orche kamash malan debaal keishto. Oh, it wants to teach us something, by the way, that a husband has the same status as his wife. And so it wants to teach us that a son-in-law would have the same law as a son. And that's why he says the uncle, his son, and that person, that son's son-in-law. If it just said son and grandson, I wouldn't know that son-in-laws are also included, even though they're related just by blood. So it wants to teach me something, by the way, and that's why it says it in this type of language. But now we have a challenge from a Braita that Rabbi Chia taught. He said that there are 8 people mentioned in the Mishnah. Actually, there are 9, but we'll deal with that in the next sugya. He said there are 8 people listed in the Mishnah that one cannot testify about, mostly uncles and so on. And then if you include the sons and sons-in-law, so each one of those 8 has a son, that's plus 8, and could have a son-in-law that's included, that's another 8, and that's how you get 24. So it's evident that Rabbi Chia is only going one generation down. If you would say that it's talking about grandsons, then you have to add another 8 also for grandsons. And if you would grandsons-in-law, maybe even another 8. But even just adding one more 8 for that next generation will take you to 32. And so clearly the Bichaya, at least, is not interpreting our Mishnah that it means son and the son's son-in-law, because that would add yet another generation, a whole another 8. But rather, it's only that one generation. Ela le'olam chatano mamash. So we're going back to reading the Mishnah according to the Peshat, that the Mishnah says all the people on this list, like an uncle, that includes the son and son-in-law of the uncle. So where did Rav get his law from? Why does Rav refer to this son-in-law as the son-in-law of the son? What he means to teach is that since that son-in-law, the son-in-law of the uncle, comes from elsewhere, he wasn't part of the family, and he marries in, we consider it as if it's another generation. In other words, you look at this diagram here. So if this is the person and he's prohibited to testify about his uncle and his uncle's son, and the simple reading of the Mishnah, and also his uncle's son-in-law. That would be his daughter's husband. Okay, so that's fine. That's clear what the Mishnah says. But according to Rav, he says an uncle's, his son-in-law is, since he's an outsider, is the same as a third generation. So therefore, you can treat a son-in-law as being the same law as a grandson. And so just like this uncle's son-in-law is prohibited, so too would the uncle's grandson be prohibited, which would in fact be the son's son-in-law. So it's not that the Mishnah actually says it. Then we're reading the Mishnah according to the Peshat, but Rav is making an equivalence to say that that includes the son's son-in-law as well. Now note that this explanation also assumes that a second generation with a third generation is prohibited, which is not actually what Rav said. So that's going to be the next question. We ask, hold on, if you accept that logic, then Rav would say that you cannot even have a third generation with a second generation, because here's second generation on this side, and on the other side, it would be the uncle's grandson is also not allowed. So it means second and third generation are not allowed to each other. But Rav actually didn't say that. Rav only said that a first generation and a third generation cannot testify about each other. He made an analogy of first cousins are not allowed. And he said, then therefore also, right, even the grandson to an uncle. But Rav never said that this is a problem. But I would say that second generation to third generation would be totally fine. So it doesn't make sense that Rav himself would use this logic and prohibit a second to a third. Rather, when Rav said this law, he was saying it within the opinion of Rabbi Elazar, who does in fact prohibit a second and third generation, as we learn in a Braita de Tanya. Rabbi Elazar Omer, Kishem Shachi Abba lo ya'id li, hu ubeno v'chatano. He says, just like my father's brother cannot testify about me, and not only him, also his son and his son-in-law. That's a first cousin, so that's the simple case of the Mishnah. Kach ben achi abba lo ya'id li hu ubeno v'chatano. So too, the son of my father's brother, meaning my first cousin, cannot testify about me. He and his son son-in-law. So here is Rabbi Elazar. It's too long to even fit on the screen. We'll put it this way. So he's saying that just like me and my cousin, we cannot testify about each other. Also, my cousin's son and son-in-law. So he says a second generation and a third generation cannot testify about each other. And this fits with the logic that Rav suggested, that a son-in-law would be the same as a grandson. Okay, fine. So Rav was saying his law for to be Elazar, but we still have a problem. So he's saying he followed to be Elazar, who says that a second and a third generation cannot testify about each other, but Rav himself only said a first generation and third cannot testify about each other, which means that according to Rav, a second and a third can testify about each other. So still does not consistent with what Rav himself said. Rav savar le kivata bechada ufaleg ale bechada. And the answer is Rav agrees with Rabbi Elazar about one law, but not about another law. He agrees that we should go down 2 generations if you're talking about the first to a third. That he agrees with Rabbi Elazar, even though the Mishnah only talked about first cousins. So Rav said, you know what? First cousins, that's 2 verticals and 1 horizontal. I think we can apply that to these 2 verticals and 1 horizontal and first and a third. And Rabbi Elazar would agree that that's prohibited. I agree with him. However, Rav did not agree that you can extend that yet another with another vertical and have a second and a third. Rabbi Elazar thought that that was not allowed. Rav thought that that was permitted. My ta'ama de Rav. What's Rav's source? Tamar kera lo yimetu avot al banim ubanim lerabot dor acher. Rav derives his law from the vav between the banim and the ubanim. So you cannot kill a father based on the testimony of the son and the son. So that is a second generation. So that's an uncle with not only his nephew, but even the son of the nephew. So that's how he gets 2 generations on one side. Rabbi Elazar, how does Rabbi Elazar derive his law that it's a second and a third are also prohibited? Al banim amar chamana pisule davot shadeh al banim. From the word al, that says that any time you cannot testify about someone, like here, a person and his great uncle, well, that will continue not only for that great uncle, but al banim, meaning another generation after that, which would be a second generation, and a third generation also cannot testify about each other. Amar Rav Nachman, Achi chamoti lo ya'id li. Ben achi chamoti lo ya'id li. Ben achot chamoti lo ya'id li. Here's a nice chart to summarize what Rav Nachman says. He's talking about himself here, and he's married to this woman, and she has a mother. That's his mother-in-law. So first he says that the brother of my mother-in-law cannot testify about me. His mother-in-law's brother, well, that's his uncle. Okay, that's good. And then he says not only that person, but also that person's son. Well, that we learned that rule. And anything that applies to an uncle also applies to an uncle's son or son-in-law. So that would be his first cousin. And not only that, also his mother-in-law's sister's son, because that mother-in-law's sister's husband would be his uncle, and he cannot testify about his uncle or vice versa, and that applies to that son also. So these are all different instances of cousins, and even though it's through marriage, because it's his wife's uncles and his wife's cousins, but that applies the same way. Okay, good. So Rav Nachman said that v'tana tuna, and this can be backed up from our Mishnah, because the Mishnah said Baal achoto, the husband of one's sister. Okay, that's just a brother-in-law. U'Baal achot aviv, that can refer to this person here, right? If we look at from their perspective, so their father's sister's husband. So that would be an uncle. So that would be this person's uncle, right? Their father, this is their father. Sister's husband would be their uncle. So they would be prohibited. And the Mishnah taught that anybody who's prohibited, not only them, but also their sons and their sons-in-law. And so the Mishnah said the same thing. Rav Nachman said it from this person's perspective. The Mishnah said it from this person's perspective. And the Mishnah continues and says, Ubal achot imo, hen ubnehen v'chatanehen. And also the husband of the mother's sister. So here, this person has a mother, and that mother has a sister who's over here. The husband of that person is also an uncle through marriage. And that, so this person and this person cannot testify about each other. This person, and this mother-in-law's husband. And therefore, not only them, but also their son and their son-in-law. And so you see that what Rav Nachman said from the perspective of this person, the Mishnah said the same thing from the perspective of this and this person. So we back it up. Amar Rav Asher, ki avenan be'ula ibayalan, achi hamiv mahu, ben achi hamiv mahu, ben achot hamiv mahu. Rav Asher says, when we were in the Bet Midrash of Ula, we were asked, what about a father-in-law's brother? Right, so here's the person we're talking about. So that's his wife's father, that's his father-in-law, his brother. Can they testify about each other? Or what about the son of that person, right? Ben achi chamiv mahu. Or what about the son of the sister of the father-in-law, right? Ben achot chamiv mahu, that's person's father-in-law's sister's son. What about all these cases? And Amar Lan, Ula answered us, and he said, Tinituha, achi v'achi abi v'achi immo, hen ubnehen v'chatanehen. The Mishnah says this, but not from the perspective of this person, but instead from the perspective of these people. It says a brother, and then it says, Achi Aviv, his father's brother. So that would be this person, this uncle, and that would include his son and his son-in-law. That's what we're talking about, same thing. And Achi Imo, the brother of someone's mother. So that's this person. This person's mother over here has a brother, and that's this person, that's their uncle, and that includes not only the uncle, but also the uncle's son and son-in-law. So you see that all these relationships are prohibited. And even though when the Mishnah says it from the perspective of these two people, so obviously the same thing would be reciprocal from the perspective of this son-in-law. Rav ikla lemizban gevile. One time Rav went to a certain place, he wanted to buy parchment. And everybody knows who Rav is, so while he's there, they ask him a halachic question. Can a person testify about the wife of his stepson? A person is married to someone. She has a daughter from a previous marriage. So this is his stepdaughter. That daughter marries someone. So this is his wife's son-in-law. Okay, it's his wife's son-in-law. But is that considered the same as his son-in-law? Can they testify about each other? Two answers. Besura amre ba'al ki'ishto. In Surah they say, a husband has the same status as his wife. And so therefore, for this halacha, we consider that daughter to be the same as his daughter, and that son-in-law to be the same as his son-in-law. In other words, if it's her son-in-law, then a husband is like her husband, or a husband is like his wife, and therefore has the same status. So therefore, no. This person cannot testify about his step-son-in-law because it's his wife's actual son-in-law, and the son-in-law is not allowed, so if it would be as if it's his son-in-law. Peput amre isha keba'ala. Pumbedita, they disagree, and they say that a wife takes the husband's status, but the husband doesn't always take the wife's status. And therefore, this is the husband's stepson-in-law, but they're not directly related, and therefore they can be witnesses against each other. Tamar Ravuna Amar Rav Nachman, Minayin she'aisha keba'ala. Ravuna said, name of Nachman, how do you know that a wife is like the husband? That goes one way, but not necessarily the other way. Dichtib, ervat achi abicha lo tegale, el ishto lo tikrab dodatecha hi, v'halo eshet dodohi, mikelal di'isha keba'ala. Because the pasuk says that a person cannot reveal the nakedness of his father's brother. Now, we're not talking about the male against male, but rather the father's brother's wife. That's by taking his aunt, he is revealing the nakedness of his uncle. So, and then it says, El Ishto, the pasuk explains, what does it mean? How could you reveal the nakedness of your father's brother if you take that person's wife, in other words, someone's aunt, because you cannot come close to her because she is your aunt. Now, actually, she's not technically your aunt. She's not your aunt biologically, but only through marriage. She is your uncle's wife. But the pasuk nevertheless calls her your aunt. So we learn from here that a wife has the same status as her husband. So even though she technically is not biologically related, because the father's brother is an actual uncle, biological uncle, she is called an aunt. So we learn from there that a wife takes on the status of her husband, but it does not necessarily mean that a husband takes on the same status as his wife. Uba'al imo hu ubeno v'chatano. The Mishnah also taught that the husband of one's mother, meaning a stepfather, that cannot testify about the stepson, and the other way around. And then the Mishnah at the end of that whole clause of the Mishnah says their children and their sons-in-law. The quote here is just paraphrasing in singular. So in other words, that person's son, of a stepfather's son or son-in-law, also cannot testify about each other. So now we ask, the son, beno, hainu achiv, isn't that person's brother? In other words, this person, their mother married someone else who's not this person's father. That's why he's a stepfather. They together have a child. That means they have the same mother, but different fathers. Well, that's a half-brother from the half-maternal brother. But that's still a brother, and brothers can't testify about each other. So we know that already. Why do you have to tell me a stepfather's son? Isn't that the same as a maternal brother? Amar Rabbi Yirmiyah says, no. We're talking about a case where the two people marry, they each have sons from different marriages. So those two sons are actually not related at all to each other. The father came into the marriage with a son. Mother came into marriage with a son. So they are actually not siblings at all. They're step siblings, but they're not half siblings and certainly not full siblings. Rabbi Yirmiyah uses an interesting phrase. It says it's the brother of the brother. It's assuming as follows, that there are three children, one only from the mother, one only from the father, like Brady Bunch. But imagine in the Brady Bunch, the two parents had a child. So then that child would be the half maternal sibling of one and the half paternal sibling of the other. So the two outsiders is a brother's brother, but they are not biologically related. So that's how he says it. And so that's what we're talking about. So we know already from the Mishnah that brothers cannot testify about each other. But from this clause, a father-in-law's son, we learned that a stepbrother also cannot testify about his stepbrother. Rav Chisda achshar be'acheh. Now Rav Chisda disagrees with this, and he says that a brother's brother, meaning a stepbrother, that they are not related at all, can testify about each other. Amru le la shemiya lach ha de Rabbi Yirmiyah. So they asked him, did you not hear the tradition of Rabbi Yirmiyah, who says that a brother's brother, meaning a stepbrother, cannot testify about each other? Amar lehu la shemiya li kilomar la sevira li. He says, I never heard of it. What he meant is, I heard of it, but I don't agree with it. Yachi hainu achiv. Now the Gemara asks, if step brothers can testify about each other, as Rav Chisda said, then you cannot use this as an answer to the question that we started with. That means when it says a father-in-law's son cannot testify about the stepson, well then that's the same as a brother, because that's a maternal brother. So we already know that from the word brother. And the answer he could give is Tana achiv mina av v'katane achiv mina em. When the Mishnah says achiv, that's talking about paternal brothers. But so we only know paternal brothers. Maybe I would think that a maternal brother, they can't testify about each other. So that's included in father-in-law's son. Father-in-law's son, assuming that the mother came into the marriage with a child, and then the mother had another child with this stepfather, and so they would be maternal brothers, and that's what is coming to add according to Rav Chisda. Amar Rav Chisda, Avi chatan v'avi chala me'idin ze al ze, v'lo damu ladadeh ela ki achla ledana. Rav Chisda says, a father of a groom and a father of the bride, meaning consuegros, can testify about each other because they're not biologically related to each other, even though their son and their daughter are married to each other. And this, you know what this is like? It's like a lid on a barrel. The lid is not attached to the barrel. It's not part of the barrel. Happens to rest on the barrel, but it's not actually related. So too, these two fathers are rest upon, right? They are related to the son and to the daughter, but separately, but not related to each other, and therefore it's permitted. Amar Rabba bar Chana, me'id adam leishto arusa. Rabba bar Chana says that a person can testify about his betrothed wife. They only did kiddushin, not yet nisuin. so they're not yet fully married. Amar Ravina lo maran ela la pukamina, aval ayulela la meheman. Ravina says that's only if he's testifying about a situation that would remove money from her, but not if it would give her money. A fiancé cannot testify in a way that would give her, his fiancé, money, because he eventually is going to marry her and will benefit from that money. So that would make him an interested party. If she's going to lose money, then he's not an interested party. That's okay, and they're technically not related. But if he's standing to gain that money eventually when they're married, then that makes him an interested party, even though technically they are not married yet. Now, even though Ravina said this, the Gemara rejects it and says, "Velohi lo shena la puke, vela shena la ayule la meheman." In fact, no, it doesn't matter. It doesn't matter whether it's going to remove money from this future bride or it's going to bring money in. A person is not considered credible regarding his fiancé. Cannot testify. And the Gemara now explains why they are not believed and they cannot testify. Betrothed cannot testify about his future bride because it says, "My datech." What were you thinking when you said that he could testify at least one way to have her lose money? Why would you think that he could testify, right? Do you think they're not related? Or maybe you're relying on the following statement, Kedamar, Rabbi Chia bar Ameh Mishmeh de Ula, or Rabbi Chia, the son of Ameh, said in the name of Ula, Ishto arusa lo onen velo mitameh la, vechen hi lo onenet velo mitameh lo, meta no yorsha, metu go back ketubata. If you have a husband and wife who are only betrothed, but only kiddushin, but not yet nisuin, and then she dies, he does not go into onen and all the laws of onenut. And if he's a kohen, he cannot become tameh to her. So in other words, the point is that from this very important deoraita law, they are not considered married. He can't even become tameh to her. And that would be a reason to say that he can testify about her because they're not married. So is this your source? We continue to quote the whole thing. And so to her, if they're betrothed and he dies, she does not enter into the law of aninut, and she cannot become tameh to him if she is a bat kohen. This is weird because actually a bat kohen is allowed to become tameh lamet. So maybe it means that she doesn't have to be if she doesn't want to be. Okay, there's commentaries here. And further it says, if she died while they had kiddushin, he does not inherit her. If he dies, then she does take the ketubah. Even though it's only kiddushin, she does get the payment of the ketubah. So is this your source to say that he can testify about her? Because after all, if he's a kohen, he cannot become tameh to bury her. So you see, they're not considered married. Well, that would not be a proof. Hatam bish'erot alat rachamana akat elav sherohi. The law of becoming tameh for a kohen, for a relative, is dependent on being she'ero, being related as flesh and blood. That's what the pasuk says. And here they are not yet related as flesh and blood. So that law becoming tameh depends on being married fully. But the law of testifying about someone is, do you feel close to the person? And here, even though you only did kiddushin but not nisuin, a person does feel close to that person and therefore has the same problem as a relative. Even though they're not fully married, still there's the problem of being a relative because they feel very close to each other, the same as if they were totally related. Chorgo lebadok. So going back to the Mishnah, let's look back at the Mishnah that said it gave a list of people. By the way, remember before we quoted the Baraita of Rabbi Chia who said there's 8 people in the Mishnah. Actually, those 8 people, if you count them, goes until Chamiv. Chamiv is the 8th. And then he says, add another 8 and another 8 for sons and sons-in-law. Giso here is actually going to be the 9th. Okay, so just note that. It's going to come up again in just a minute. According to the Mishnah, Giso, someone's brother-in-law, is included in the list, and that would be a brother-in-law and the next generation of the brother-in-law's sons and sons-in-law. But the Mishnah says a stepson is only one generation. That's it, stepson. but not a stepson's son or son-in-law. That's what the Mishnah said. So that's what we're going to analyze. Tenor Rabbanan, Horgo lebado, Rabbi Yosef Omer Giso. So the Tanakama of this Baraita says, a stepson alone, only one generation. Rabbi Yosef disagrees and says something about Giso, but it's a very short Baraita. We're not sure, is he disagreeing about Chorgo? Is he saying Giso is the same as that? Is he flipping it? We don't know. V'tanya idach, to make matters more complicated, there's another Braita that is the opposite of that first Braita. It says Giso lebado, Tanakama of this Braita says, when it comes to brother-in-law, that alone, and Rabbi Yehuda Omer Chorgo, Rabbi Yehuda says, no, stepson alone is only one generation. And that means, what does Rabbi Yehuda say about the other one? Not clear at all. So, Mai Ka'amar, what does this mean? Ile mahachi Ka'amar Chorgo lebado, v'uadin legiso. If it means, the Tanakama says, when it comes to a stepson, only one generation, and this opinion says that's the same for a brother-in-law, so it's actually the same. And in that case, Rabbi Yosef comes and says, no, I think that Giso, a brother-in-law, is one generation, and I agree also regarding a stepson. Well, in that case, actually, Tanakama and Rabbi Yosef agree with each other, so this whole Baraita would not make any sense. There's no machloket because they both think that Chorgo and Giso are only one generation. So then why are they even talking about it? So this doesn't make sense on its face. But a further problem is, Ela matnitin de katane Giso hu ubno v'chatano maneh lo Rabbi Yehuda velo Rabbi Yosef. Our Mishnah that says regarding a brother-in-law, that will include the next generation. But stepson will not include the next generation. Whose opinion will this be? It won't be Rabbi Yehuda, it won't be Rabbi Yosef, because according to the second Braita also, if that also means the same thing, that Tanakama, whoever it is, well, maybe it's Rabbi Yosef, right? And then it calls Rabbi Yehuda as the other, and the first Braita, Rabbi Yehuda, is an unnamed Tanakama, and Rabbi Yosef is the other one. The point is that either way, they're all saying the same thing. So if both Rabbi Yosef and Rabbi Yehuda think that both a brother-in-law and a stepson are also only one generation, well then neither of them can follow the Mishnah. So then who is the author of the Mishnah? ואלה הכי כאמר חורגו לבדו, אבל גיסו הוא בנו וחתנו. ועתה רבי יוסף למאמר גיסו לבדו, אבל חורגו הוא ובנו וחתנו. So maybe you'll say, interpret the first Braita as follows, that the Tanakama says that a stepson alone, but according to Tanakama, a brother-in-law goes to the next generation. And Rabbi Yosef comes and says, no, I flip it around. And I think that a brother-in-law is only one generation and a stepson goes 2 generations. So if that's the case, well, then we have an author of the Mishnah, so that would be okay. It would be the Tanakama. But ve'ela hadetaneh Rabbi Chiya shemona avot shehen 24 keman lo keRabbi Yosef velo keRabbi Yehuda. But then how will we explain the Braita that Rabbi Chiya quoted, that there's only 8 people that include the son and son-in-law, because that makes 8 plus 8 plus 8 is 24. Who would that follow? Not Rabbi Yosef and not Rabbi Yehuda. Because you're assuming Rabbi Yehuda is the Tanakama of this Braita, and the other Braita is just the same. Also, Rabbi Yehuda and Rabbi Yosef flipped around. The problem is that Rabbi Yosef and Rabbi Yehuda, each one of them, except one or the other, brother-in-law or stepson. And so, back to the Mishnah, the Mishnah has 9 people. So if you're going to say, okay, instead of Giso is 2 generations, it's Chorgo, right? So, but everybody agrees that either Giso or Chorgo go an extra generation. Then there's 9 people who go an extra generation, and Rabbi Chiya said only 8 people. So who's going to be the author of the Baraita? It can't be Rabbi Yosef, it can't be Rabbi Yehuda, because they both think that there's 9 people. Rather, it must be that Tanakama, who would be Rabbi Yehuda, He thinks that when it comes to the stepson, that's only one generation. But when it comes to a brother-in-law, then it goes an extra generation. But Rabbi Yosef disagrees. And he says, well, no, brother-in-law is only one generation. And all the more so a stepson, that for sure it's even a more distant relationship. And therefore, that would also be only one relation, only one step. Umat nitin Rabbi Yehuda. But Aita Rabbi Yosef. Now the Mishnah will follow Rabbi Yehuda. He thought that Giso goes the next generation, which is what the Mishnah also said. Giso and Chorgo is only one generation. So the Mishnah follows Rabbi Yehuda, and the Braita that Rabbi Chia quoted, that author would be Rabbi Yosef, because Rabbi Yosef rejects both son-in-law and all the more so stepson. That there's only one generation, and that leaves only 8 people where you include the son and son-in-law. Amar Rav Yehuda Amar Shmuel halacha Rabbi Yosef. Rav Yehuda says in Shmuel, surprisingly, the halacha goes against the Mishnah, but rather is like Rabbi Yosef, that there's only 8, also like the Beraita of Rabbi Chia. And therefore, both Giso and also Chorgo would be only one generation. And now we have an interesting story. Yahi matanta davechatime ale tere gise. There was a deed of gift that said this person is giving gift to some other person, and there were 2 witnesses, and the witnesses were brothers-in-law. Now, this would seem to be totally no good, because all the opinions before, we were just arguing about whether the brothers-in-law go to a next generation, or brother-in-law's son. But everybody agreed, even Rabbi Yosef agreed that the brother-in-laws, the first generation, cannot testify about each other. So it would seem that this would be definitely no good. But here we have something surprising. Rav Yosef thought, this deed should be valid because Shemuel said halachas like Rabbi Yosef. Now, it can't be the statement of Rabbi Yosef that we were just talking about, because there Rabbi Yosef just said that a second generation can be testify about a son of a brother-in-law is okay, but brother-in-law themselves cannot be okay. Here's what he thought. There's another statement of Rabbi Yosef in our Mishnah. So back to our Mishnah. The next paragraph says, Amar Rabbi Yosef, Zo Mishnat Rabbi Akiva. This list of all these 8-9 people is according to Rabbi Akiva. That includes paternal and maternal side. However, Rabbi Yosef says the original law, and Rabbi Yosef seems to be saying that he would follow the original, they follow the original law, and if halacha is like Rabbi Yosef, then this would be the law. And it says here only an uncle and a cousin and anyone who can inherit, which is only on the father's side. And brothers-in-law would not inherit from each other because they're not brothers. They don't have the same father. So there's no way that brothers-in-law would inherit from each other. And so Rav Yosef thought that when Shemuel said halacha is like Rabbi Yosef, that Shemuel meant Rabbi Yosef in the Mishnah. Halacha is like him. And Rabbi Yosef in the Mishnah would say that brothers-in-law don't inherit from each other, and therefore they can testify about each other. And that's why Rav Yosef said that this deed of gift is a valid deed. Amar Abaye challenged Rav Yosef, and he says, Memai de Rabbi Yosef de Matnitin. Why do you think that Shemuel was referring to the Rabbi Yosef of the Mishnah, that the halacha is like him, the Machshar Begiso, who says that brothers-in-law can testify about each other? Dilma Rabbi Yosef de Baraita de Pasil Begiso. Maybe we're talking about Rabbi Yosef of the Braita that we just quoted above, who says that brothers-in-law cannot testify about each other. It's true, he says a brother-in-law's son can testify, but brother-in-law themselves cannot, and therefore this deed of a gift is no good. And Rav Yosef answered, La sakadatech tamar Shemuel kegon ana upinchas. Tavyan ache v'giseh, aval giseh de'alma shapir dameh. He said, Yosef says, no, that can't be, because Shemuel also said that you want to know who cannot testify about each other. He gave an example, like me and Pinchas. Now, Shemuel and Pinchas were brothers, biological brothers, and they also married two sisters so that they were also brothers-in-law through marriage. So they were brothers and brothers-in-law. So, right, and that's what he says, because we are ache, brothers, and brothers-in-law. Meaning, that's why we cannot testify about each other, because we are brothers. But if we were only brothers-in-law, like usually people are not brothers, they're only brothers-in-law, then that would be okay. They could testify about each other. So since Shemuel said that, evidently Shemuel, when Shemuel said Al-Chaz like Rabbi Yosef, he must have meant Rabbi Yosef of the Mishnah, who says brothers-in-law can testify about each other. But Rabbi says that's not a necessary understanding of Shemuel. Maybe when he says me and Pinchas cannot testify about each other, what he meant is because, number one, we're brothers. And independently of that, number two, we are brothers-in-law. So he didn't mean that if we were only brothers-in-law, we could testify. He meant we definitely cannot testify each other on two counts. And really, he said brothers-in-law cannot testify about each other, which means he did not think halacha is like Rabbi Yosef of the Mishnah, but rather Rabbi Yosef of the Baraita, and therefore brothers-in-law cannot testify. Amar le zil kanya be'adeh mesira k'Rabbi Elazar. So Rav Yosef had to give in because he did not have a proof, and that Shemuel permitted it, and therefore he says, okay, maybe you're right. And brothers-in-law cannot testify about each other. Therefore, he told the bearer of this deed, listen, go find the witnesses who saw the transfer. Those were other witnesses, not the ones who signed it. Those were valid witnesses, not related to each other. And we'll follow the opinion of Rabbi Elazar. Rabbi Elazar says that the witnesses who observed the transfer, we can follow them. They validate the contents of the document that they see go from the gift giver to the gift receiver, and we can ignore the signatures that are on the deed itself. So he says, do that. But then Abaye says, no, you can't do that either. Rabbi Elazar, although he says that you can rely on the witnesses to transfer, that's only if there are no witnesses in the document itself. That's totally fine. No witnesses in the document, but witnesses saw them transfer. Then you could use that. But if you have a document with invalid witnesses, it's invalid inherently because there are invalid witnesses, brothers-in-law signed on it, then even Rabbi Elazar would say, no, it's not good enough to use the Edeh Mesira because there's a problem with the signatories. It's okay if you have no signatures, but if you have bad signatures, then it's totally invalid. Amar le zil la shabki li de'ot bine lach. And finally, Rav Yosef gave up and he said, sorry, I tried to help you, but I can't because they did not let me give you the gift. Every time I try to bring an argument, I want you to win. I want you to have the gift. I think it's really yours. But everything I say, the other rabbis would object, and therefore he has no proof that this is good, and in the end, he could not help this poor gift receiver. Baruch Adonai Le'olam, Amen ve'amen.